Hello students, in this video I am going to discuss about the nature of Nikah, why Muslim marriage is regarded as civil contract, and then the essential requirements of a valid Nikah or Muslim marriage. So first of all, while you are writing the answer, this question will come for 12 marks. So you have to attempt the question as introduction, then body part and then conclusion. So in introduction you have to write the concept of Muslim marriage. The Arabic word nikah or marriage literally means the union of sexes and in law this term means marriage. In pre-Islamic Arabia, this term meant different form of sex relationship between a man and a woman established on certain terms. In Bailey's Digest, marriage has been defined to be a contract for the purpose of legalizing sexual intercourse and procreation of children. So this was the concept of nikah. Now, what is the nature of Muslim marriage or nikah? There are divergent opinions with regard to the nature of Muslim marriage. Some jurists say the Muslim marriage to be purely a civil contract, but according to some other jurists, it is a religious sacrament in nature. So there are two views regarding Muslim marriage. According to some jurists, they say that Muslim marriage is a contract, and then the other jurists say that Muslim marriage is a sacrament. So why Muslim marriage is regarded as civil contract? You have to write this. Muslim marriage is treated as a mere civil contract and not a sacrament by some text writers and jurists, as it has some similar characteristics as a contract. They are: number one is a Muslim marriage nikah requires proposal ijab from one party and acceptance or kabul from the other party. Moreover, there can be no marriage without free consent, and such consent should not be obtained by means of coercion, fraud, or undue influence. Then, number two, in case of Muslim marriage, both the persons have to attain the age of puberty. Under the Muslim law, 15 years is the age of puberty or majority, but under the Indian Majority Act 1875, the boy should attain age of 21 years and the girl should be of 18 years. Point number 3 is dawar or meher is the most essential and important condition of nikah. Without dawar, the marriage cannot be valid or sahih marriage. Number 4 is, although discouraged both by Holy Quran and Hadith, yet like any other contract, there is also provision for the breach of marriage contract. Now, the analogy of marriage among Muslims as a contract was pointed out by Justice Mahmood in the leading case of Abdul Qadir versus Salima, and Justice Mitar in Sobronisa's case. So, describing the nature of Muslim marriage, Justice Mahmood observed that marriage among the Mohammedans is not a sacrament but purely a civil contract, and though it is solemnized generally with recitation of certain verses from the Quran, yet the Mohammedan law does not positively prescribe any service peculiar to the occasion. That it is a civil contract is manifest from the various ways and circumstances in and under which marriages are contracted or presumed to have been contracted. Another view is that marriage is not a purely civil contract but a religious sacrament too. Though sacramental nature of marriage is considered as an orthodox view, it is also supported by the judiciary. CJ Sir Shah Sulaiman has tried to put a more balanced view of the Muslim marriage by holding it both a civil contract and a religious sacrament in the case of Anis Begum versus Muhammad Istafa. Now, essential requirements or conditions of a valid Muslim marriage. Though in Muslim communities certain social functions and ceremonial rites are performed at the time of marriage, such functions and rites are not legally necessary. The solemnization of marriage requires adherence to certain terms and formulas. They are called essentials of valid marriage. If any of these requirements is not fulfilled, the marriage becomes either void or irregular, as the case may be. Now, the essentials are as follows. So, the essentials are as follows. Number one is proposal and acceptance. Number two, competent parties. Number three, no legal disability. First of all, proposal and acceptance. Muslim marriage under the Muslim law is constituted by ijab or qabul. Like any other contract, one party to the marriage must make an offer or ijab to the other party. The marriage becomes complete only when the other party has accepted that offer. So, proposal and acceptance is done here. Now, according to the Muslim law, it is absolutely necessary that the man or someone on his behalf and the woman or someone on her behalf should agree to the marriage at one meeting, and the agreement should be witnessed by two adult witnesses. There must be reciprocity between the proposal and acceptance. The acceptance must not be conditional. Under the Sunni law, the proposal and acceptance must be made in the presence of two males or one male and two female witnesses who are sane, adult and Muslims. Absence of witnesses does not render marriage void or irregular. Under the Shia law, witnesses are not necessary at the time of marriage, they are required at the time of dissolution of marriage. Number two is competent parties. What do you mean by competent parties? So in this point there should be a first point is age of majority. Age of majority or age of marriage. The parties to marriage must have the capacity of entering into a contract. Muslim who is of sound mind and who has attained puberty may enter into a contract of marriage. Now what is puberty? Puberty means the age at which a person becomes capable of performing sexual intercourse and procreating children. In Muslim law, puberty and majority are the same term. Majority is presumed among the Hanafis on the completion of 15 years for both males and females. In case of a Shia female, the age of puberty begins with menstruation. The Privy Council held that the age of majority for a Shia girl is 9 years. Muslim law in respect of marriage, dower and divorce has entirely left untouched by the Indian Majority Act 1875. It should be noted that marriage of a minor without the consent of the guardian is invalid. A boy or girl who has attained the puberty is at liberty to marry anyone he or she likes, and the guardian has no right to interfere if the match is equal. Jammu and Kashmir High Court in Abdul Ahad versus Shah Begum had held that a marriage of a minor girl, even contracted by wali, is invalid ab initio. Now, number 3 and last point is no legal disability. Legal disabilities means the existence of certain circumstances under which a marriage is not permitted. These prohibitions have been classified into four classes as follows. Number 1 is absolute incapacity or prohibition. Number 2, relative incapacity or prohibition. Number 3, prohibitory incapacity or prohibition. Number 4, directory incapacity or prohibition. Number 1, absolute incapacity. What is meant by absolute incapacity? Absolute incapacity may arise from consanguinity, affinity, and fosterage. What is consanguinity? Consanguinity or Kurabat. Consanguinity means blood relationship and births from marrying his mother or grandmother, how howsoever, his daughter or granddaughter, how lowsoever, his sister, whether full, consanguine, or uterine, his niece or great niece, how low soever, his aunt, father's sister, mother's sister, or great aunt, how high soever, whatever parent, paternal or maternal. Number two is affinity or musharat. A man is prohibited from marrying number one his wife's mother or grandmother, how high soever. Number two is his wife's daughter or granddaughter, how low soever. Number three, wife of his father or paternal grandfather, how high soever. Wife of his son or son's son or daughter's son, how low soever. And number three, fosterage or riza. When a child under the age of 2 years has been suckled by a woman other than its own mother, the woman becomes the foster mother of the child. A man may not, for instance, marry his foster mother or his daughter or his foster sister. Number two is relative incapacity. Relative incapacity springs from cases which render the marriage invalid. Following are the causes of relative incapacity. Number one is unlawful conjunction. Number two, polygamy. Number three, absence of proper witness. Number four, difference of religion. So now, number three is prohibitory incapacity. Prohibitory incapacity arises from the following cases: polygamy and a Muslim woman marrying a non-Muslim. And the last one is directory incapacity. This may arise from marrying a woman, ancient prohibition of divorce, marriage during pilgrimage, and then marriage with a Sikh man. So this was a detailed discussion on the nature of Muslim marriage and then the essential conditions or requirements of a valid nikah or Muslim marriage. So if you don't understand any term, please comment in the comment section. I shall be trying to solve your problems. So to get more videos regarding Muslim law or any other law subjects, please subscribe to my channel and share with your friends, like the video and comment how it was. Thank you for watching the video. Have a great day.